my talk.
Thank you so much, ma'am. Thank you, Ariman.
Before I begin my talk, I would like to wish all of you, each one of you, a very happy Environment Day. And it's a World Environment Day. And I had decided to deliver a talk on this particular day to make everybody aware that environment is so important to each one of us. And we, as citizens of the country, and also members of the globe, we have accountability and responsibility towards the preservation of the environment in various aspects. Thank you so much for inviting me today for this talk. I think most of you must be now really tired of attending a series of webinars, but there seems to be no other option when we are all under lockdown. This is the most fruitful way of emanating legal education and also keeping in touch with what is happening around us and within our country and even at the international level. Now today my talk is going to be on air pollution, like judicial activism in the protection and prevention of air pollution. We are all aware that we are going through difficult times. It's not only through COVID-19 period that I'm talking about, but per se, air pollution has been really troubling India a lot in every respect, especially in metropolitan cities. And I like to mention Delhi is right on top. I'll come to that later. Now, air pollution causes a lot of problems to all of us. And we've seen little children also being vulnerable to various respiratory problems, not only besides the elderly and even the adults. And we saw last December, I think beginning from maybe November or before that also, that there was a thick smog which had engulfed the entire northern India, and Delhi NCR region was worst. So we all have to, be alert, and we have to be awake to the problem. Now, unlike the Water Prevention and Control of Pollution Act, 1974, which was enacted under Article 252(1) of the Constitution of India, after 12 states made a request to the Central Parliament for an enactment, a central piece of legislation. Now, the Air Act was not made after a request was made to the Parliament. It was made after we had the Stockholm Conference in the year 1992 on human environment. And it was basically to implement the decisions laid down in this conference, United Nations Conference on Human Environment in Stockholm in the year 1992. This is what the preamble of the Air Act also says. Now, the Air Act was enacted by the Parliament by virtue of Article 253(1) of the Constitution of India, which empowers the Parliament to make legislation to implement any international treaty, convention, declaration, or any kind of guidelines laid down at the international level in its domestic law. So this is what the Parliament did for India. Now, if you look at the Air Act and the Water Act, both the acts are similar. The Air Act is similar to the Water Act with a few differences here and there. Now, in the 1980s, we had a new legislation called the Environment Protection Act 1986. Now, before this, we already had two codes in place. That is the Water Act and the Air Prevention and Control of Pollution Act. Both these acts were self-containing codes. When the Environment Protection Act was enacted, it was an umbrella legislation, and it took within its ambit the entire country. All right? Now, the Air Act and the Water Act, both the acts, had to make amendments to suit and be in compliance with the Environment Protection Act 1986. Now, a very important feature of the Air Act is Section 19, which empowers the government to notify certain areas as air pollution control areas. Now, whenever the government concerned declares or notifies through a gazette that a particular area is an air pollution control area, then any industry, process, or operation if at all it has to be started in that particular area, must get the consent from the State Pollution Control Board regarding the permit system, permission, all these allied things have to be first sanctioned by the State Pollution Control Board before the particular industry, operation, or establishment can be set up. Now, there is a very significant section under the Air Pollution Prevention and Air Pollution Act, which is Section 43, which is about citizen suits provision. This is a similar section you'll find under the Water Act, and it is also there under the EPA. EPA, I'm using it as a short form for the Environment Protection Act. Now, this particular section gives a lot of power to the citizens to invoke the Air Act in case any polluter is not complying with the conditions or with the license given or the guidelines given by the State Pollution Control Board. Now, the power is given to the citizens, I agree, but there is also a rider to it that a 60 days notice should be given. So what happens usually, when a 60 days notice is given to the polluter, he very calculatively and very cleverly just finishes off the evidence which he has, which would be a sample of, okay, he's committing pollution. So this is a very major lacuna in the Act which has not been taken care of. Now, whenever an industry or process or operation violates the rules of the Air Prevention and Control of Pollution Act, then it is within the competency of the State Pollution Control Board or even the Central Pollution Control Board to issue guidelines or issue orders for the closure of the polluting industry or to withdraw the electricity or water. Now, an important fact which all of you should understand is that there are no separate state pollution control boards for dealing with air pollution. So the same pollution control boards, which are in the state, and also the Central Pollution Control Board, which are there or which is there under the Water Act, would also take care of air pollution. So the boards are the same. Okay, they don't have separate boards. As it is, there's a lot of problem with the state pollution control boards. There is corruption, there is, complacency, there is apathy. And as you will know when I discuss some case law with you, that the municipal authorities have not been working, the pollution control boards have not been working, and that is why the pollution has not been contained in many areas. Now, under the Air Act itself, there are rules and there are sections under which norms can be issued to the industries, emission norms, that is, that you cannot exceed the particular standards. Beyond this, you cannot go, otherwise it will be violating the pollution laws. Now, when there is a conflict between notification made under the Air Act and notification issued under the EPA, then a problem ensues. Okay, here there is section 24 of the EPA Act, which says where there is overlapping, of course, the notification issued under EPA would be implemented. Now, in addition to this, students, we have the Environment Protection Rules 1986 also, which are there to implement the law laid down under EPA. Now, under these rules, there are many, rules notified for making specific industries complying to certain rules, and in the absence of specific industries, general industries. Now, there is something called National Ambient Air Quality Standards, which are also issued under the EPR, and they give, they lay down standard norms for the residential areas, industrial areas, and rural areas. Apart from these, rules are also made under the Environment Protection Rules for regulating pollution with matters dealing with emissions from the motor vehicles and also with noise pollution. We don't have a separate section on noise pollution. The Air Act takes care of noise pollution also. And of course, noise pollution is also taken care of under Section 6 of the EPA. Now, this is in brief the working or the function of the Environment Protection Act. Now, let us look at judicial activism now. Most of the environmental jurisprudence, largely, I'd say, is a product of judicial activism. Because in a country like India, because we have many issues like population, poverty, other reasons, lack of funds, people not working, no coordination between states, between centers. And then we have list 1, list 2, list 3. Then we have the federal structure, which sometimes comes in environmental matters. Keeping all these issues in mind, the judiciary had to step in many times. Now, the judiciary stepped in under public interest litigation. I'm sure all of you are aware what it means. Some people also call it social action litigation. Now, under this concept of litigation, the concept of locus standi has been greatly widened. So any public-spirited person or any Samaritan, any NGO, any body, any individual, any class of people can go and file a petition, a writ petition under Article 32 or Article 226 of the Constitution of India for relief in environmental matters. And students, you must be aware of the writ procedure. It is a procedure which is a summary procedure, supposed to be less expensive, speedy. So that also takes time. Nowadays we've seen that. And you can get interim orders relief for issues that affect the public at large, for pressing issues. Now, as environmental matters are concerned relating to air pollution, the first case which came before the Supreme Court under PIL was the rural litigation and entitlement Kendra versus State of UP case. This was in the year 1988. For the first time, it was entertained as a PIL for environmental issues. Now, in this particular case, what had happened was that there was indiscriminate limestone quarrying carried out, by enterprises in the Mussoorie-Dehradun region. The Mussoorie-Dehradun region is a very fragile place. The ecology is very sensitive. So many landslides were being committed. Cattle over there was being affected. Flora, fauna was adversely affected. People were also being troubled because of the pollution caused as a consequence of limestone quarrying. And this particular NGO filed a petition in the Supreme Court of India. Now, the Supreme Court of India, it constituted 3 committees at that particular time. Those 3 committees went to assess the site, went to assess the extent to which air pollution was caused, and they gave different reports. Most of their data matched with each other. So as soon as the data was received by the Supreme Court, it was very upset, and it issued the closure of many enterprises or these industries which were under the severe categories causing severe pollution. They were divided into A and B and C also. And certain industries were told to relocate to the outer skirts of that fragile ecology. Now here, the question before the court was how to balance between right to livelihood and right to health, or right to a pollution-free environment. And if you recall, I want you to remember Olga Teller's case, which was decided by Supreme Court, where in that case, for the first time, the right to livelihood was read as part and parcel of Article 21 of the Constitution by the Supreme Court, because in that case, the pavement dwellers had to be evacuated, by force by the municipal council in Mumbai, and they would have lost their jobs because all of them were working in that area, and even the men's wives were working in the societies around that place. So there were many activists who fought for these people. One of them, I remember, was Shabana Azmi also, in addition to others. And for the first time, the court laid down over there the right to livelihood is part and parcel of right to life under Article 21 of the Constitution. So when this particular matter came before the court, rural litigation and entitlement Kendra case, the court was in a fix, because on the one hand, you had the right to health, the right to live in a pollution-free environment, And on the other hand, it was means or right to livelihood. But here, the courts took a stand and said that when larger interests of the public is affected and health of larger number of people will be adversely affected, we have to take a decision and we have to order closure of these industries, even if the workmen are going to suffer. But the Supreme Court took care that, okay, we issue guidelines that as soon as these industries relocate somewhere else and also start operating, that they will give jobs to these very workmen who lost their jobs. So a balancing kind of an act was done by the court. Now, before I go to the different cases taken up by the Supreme Court under air pollution, I would like to explain to you the different legal principles laid down by the Supreme Court, which it got from the international environmental law, okay, and which today are part of our land, part of the land of India, it's our law of the land. Now, one is the polluter pays principle, the other is the precautionary principle, the third is the public trust doctrine, fourth is the intergenerational equity, then we also, we can also say doctrine of sustainable development, and also, which is a product of Indian jurisprudence, we have doctrine of absolute liability, okay? Now, this particular doctrine of absolute liability, students, was laid down in oleum gas leakage case. Okay, it was MC Mehta's case only. MC Mehta was President of India. It was in 1987. And I just want to deal with the facts of the case in brief. This was a factory, an enterprise which was running in Najafgarh Road in Delhi, and it was producing oleum gas. And one of the units of the factory collapsed and oleum gas leaked. It leaked to such an extent, then all the people who were standing on the paths, on the roads, leading to Tisazari were affected by this leak. And there was a lawyer in Tisazari who was already a heart patient, but as a result of inhaling this gas, he died. And he was in fact a resident of Model Town, where we used to stay earlier. Now, when this matter came before court, of course there were contentions about, the principle of Ryland versus Fletcher, like where strict liability was laid down in Ryland versus Fletcher in the year 1868, that whenever a person is dealing with something inherently dangerous and that particular thing escapes and causes damage, then the rule of strict liability would apply, and the exceptions were also there, like act of God, plaintiff's own fault, third-party intervention, and also voluntary non-fit injuria. Now, the principle of strict liability catered to anybody who was injured when that person was outside the premises within which the accident or some kind of an event had ensued. Okay, so gradually the concept of strict liability got diluted over the years in England in various cases. So when this particular aspect was taken up in oleum gas leakage case, Justice Bhagwati was not happy. He was the Chief Justice of India at that time, and he was also one of the pioneers of public interest litigation processes. He said that why should we be holding on to English law all the time, to English jurisprudence all the time? He said, okay, strict liability had with it various exceptions. So there was always an escape door where the defendant could escape from. Okay, so he said a socio-economic or cultural setup of a country is totally different. Okay, we are an agricultural country largely. Then we have workers who are working in cities. We have daily wage earners who need a lot of care and attention. They cannot afford so many things. And when permission is given to a body or to an enterprise to start something which is hazardous in nature, in the production of a hazardous substance, it may be for development reasons, or that particular enterprise is dealing with something inherently dangerous, then it is the duty on the owner of the enterprise, which is a non-delegable duty, that he or she would be liable not on the principle of strict liability, but on the doctrine of absolute liability, which closes the doors for all the exceptions that go with the rule of strict liability. So this was a new form of jurisprudence that have evolved in our country, and impliedly, Justice Bhagwati said that the right to life, here again, right to a pollution-free environment, is read in Article 21 of the Constitution. He did not say it blatantly because there was another issue in this case about Sriram Food and Fertilizers being a public undertaking or not. And if it was not a public undertaking, why did the court accept the PIL under Article 32 of the Constitution when Article 32 of the Constitution only deals with the violation of fundamental rights and none other rights? So Justice Bhagwati did not want to open the Pandora box at that particular time. He wanted to give relief, and he gave it. And along with this, he gave another proposition. And he said that in our case, when an enterprise, there is an accident, an enterprise is dealing with a hazardous substance, and it causes damage not only to people within the premises, the complex of the enterprise, they would also get the benefit, but people outside also. So there was a deviation from the principle of strict liability as propounded by Justice Blackburn in Ryland versus Fletcher's case. I hope you're understanding. Another point he made was that when an enterprise is producing on such a large scale, that enterprise is also making a lot of money. Okay, so it is the duty of the enterprise to pay compensation to the victims who are injured, irrespective of the nature of injury, however trivial it may be. It would be based on the larger the pocket, the greater the amount of compensation to be paid to the victims of such an accident. So this was the jurisprudence laid down, which has become very significant to today's students. Now, this particular case, and also Justice Bhagwati wanted to give a very befitting reply because Bhopal tragedy had also happened. But the decision in Bhopal had not taken place. So he wanted his decision to have an influence upon the Bhopal tragedy case also. But unfortunately, Bhopal tragedy case did refer to the MC Mehta's case, oleum gas leakage case. But the fact that larger the pocket, larger the amount to be paid, the court did refer to it in Bhopal case, but it said it would not apply in such a situation because firstly, UCC said, Union Carbide Corporation, that this is jurisprudence which is very Indian in nature and we will not follow it. Okay? And also finally, in the Bhopal case, the settlement was made outside the court. So the question of the doctrine of absolute liability becoming the law of the land was not clear till we had the Bichri Village case in environmental matter. Bichri Village case is the H acid case, students, which we had, I'll just give you the name of the case, Indian Council for Enviro Legal Action versus Union of India, AIR 1996, Supreme Court 1446. Here again, student in Rajasthan, in the district of Udaipur, there were a group of chemical industries. Except for one government industry, all were owned by private people. And they were emitting a lot of sulfuric acid gas, and also H acid was being produced. Now, H acid was very lethal. It was banned abroad, and it was also banned by a decision given by the High Court in Gujarat that it should not be produced even in India. But these particular industries were producing it for export. And also there was a lot of sludge which had collected outside these particular industries, and there was hue and cry in that place. The villagers were running away. The color of the wells was a murky red. The people could not even use the water for their daily chores. They could not have any drinking water. The matter was taken up in the parliament, and finally when it came before the Supreme Court, it was discovered that the responsibility was being passed on to the Rajasthan State Pollution Control Board, to the state government of Rajasthan, to the Ministry of Environment and Forest in Delhi, to the Central Pollution Control Board. One after the other, nobody wanted to take up the responsibility and remove the slurry or the sludge which had collected outside all these industries. In fact, the villagers had to leave that particular place because their life was in danger. And a lot of air pollution was caused and water pollution. And I want you to understand that consent under the Air Pollution Act and Water Pollution Act was mandatory for these industries. And when evidence was brought before the court saw, the Apex Court, that in many cases the licenses were either not renewed or they did not comply with the effluent treatment processes. So it was a very sad state of affairs. And the Supreme Court was very upset. And it said that it's very sad that all these bodies, statutory bodies, are fighting with each other and they're not taking care of the environment. And it said very categorically that in environmental matters, we should not take up adversarial litigation. It should be more like combined, inquisitorial, because it concerns all of us. All of us have a duty. All of us have a responsibility towards taking care of the environment. And the councils of either parties should not keep on blaming the other party that, they are not doing or we are not doing. That is wrong, the court said. And it also had to call NEERI, the National Environment Engineering Institute from Research Institute from Nagpur, to study the site and give data. And in this case, students, this was the first case where the Supreme Court laid down the doctrine of absolute liability and applied it and said it is law of the land. And even though the four industries were private industries, they said that if private industries are causing environmental harm, we will not, give shelter to the people and say that, okay, it's not a violation, it's not a public body, or it's not a state. And so we cannot give them relief. They said, no, we will get up and give justice to these people. So this is today. Now, doctrine of absolute liability is law of the land. It has been laid down, but years after the oleum gas leakage case. Now, again, before I go to other cases, I like it to be connected to the recent accident which happened in Vizag, in Visakhapatnam. Here also, the NGT has ordered 50,000 crores to be paid by LG Polymers to the people, and the amount should be given to the district magistrate at Visakhapatnam. But they have gone, again, they went to the Supreme Court and said that NGT does not have jurisdiction. And the Supreme Court has sent them back and said, no, it's the correct forum. NGT has to exclusively determine. And it had taken suo moto notice of this, and the proceedings have started. Now, here, the NGT has said it's a violation of the rule of strict liability. Rule of strict liability will apply. But I would not agree with this, because again, rule of strict liability means where the land is subject to non-natural use, there is escape, and the escape causes damage. So that means in this particular Vizag incident, the people who were within the territory of the enterprise, LG Polymers, they would not get any relief. So this again should come under the doctrine of absolute liability and not strict liability. Because once you say it's strict liability, then you open the room for the exceptions to come in. You understand? But if the doctrine of absolute liability imposed, then that escape door is closed. So it's no fault liability. Not that strict liability does not take in complaints if they are not dealing with negligence at all. Negligence doesn't come in. Please remember, students, negligence will not be taken into account at all. Now I'll go to other cases. There are lots of cases, students. I take up the Taj Reprism case now. You've all heard about the Taj Mahal. This is in MC Mehta versus Union of India. AIR 1997, Supreme Court 734. Now here, there were more than 200 glass industries and other coke coal industries which were emitting a lot of smoke and a lot of pollution, which was making the marble of Taj Mahal turn yellow. In addition to this, there was also the Mathura refinery that was emitting sulfuric dioxide, which was also causing a lot of harm to the Taj Mahal. Now, when the matter came up before the Supreme Court said that it is not only that the health of the people is important for us, under the Constitution of India. But also, we have to take care of monuments which are a wonder of the world, okay? That they are not spoiled in any way. The court in this case not only quoted Article 48A, duty of the state, Article 51AG, duty of the citizens, Article 47, again, duty of the state to improve the public health of the people and improve the nutrition, and Article 49 of the Constitution of India, which is again a directive principle of state policy. It says that the state is obliged to save monuments of historical importance and architecture from spoliation, damage in any way. So this is a duty which is there on the state governments and the central government. So here, orders were passed against this particular to the state government to take care, and also the central government to take care that the Taj Mahal is protected and a green belt is allowed to be grown around the Taj Mahal, so that they are protected from the motor vehicle emissions also. Now, students, many years had passed. This particular case took place in 1997. Okay. Now, in 2012, MC Mehta again went to the court. He found that the Mathura refinery was again polluting. Per hour, sulfuric acid was being, emitted, and Taj Mahal was again being affected. So here the court again issued directions. And said that it's very sad that the concerned authorities have not taken action. The court said contempt proceedings will be initiated if they do not follow our guidelines. In our country, what happens is that the Supreme Court has given dynamic judgments, very good judgments, but the way they are implemented at the ground level is a cause for concern. Because even in Ganga pollution cases, the judgments are beautiful, the guidelines are beautiful, but again the follow-up becomes an issue, and that is another body which should be set up by the country, by the center, which should follow up every decision of the court. Okay, now I'll go to some other cases, students. There's another case by the name of Consumer Education and Research Society case. This was in 1995, January. In this case, students, there was a factory, an industry which was dealing with asbestos, manufacturing of asbestos. Now that was causing a lot of pollution to the workers, and they were having respiratory problems. Now, the particular rules of that industry said that people who retired would not get benefit of, the medical benefits or any kind of compensation if they developed respiratory diseases, and also in the form of cancer. Okay. Now, this was of course brought to the knowledge of the court, and the court gave a very progressive judgment and said that the right of the workers who have worked in such an industry continues till the end. It doesn't mean that after you retire and if you get cancer as a consequence of working in the asbestos industry, you are not entitled to compensation or medical benefit. So this particular judgment was given in favor of the workers. They said no, they will all get, even if the particular factory relocates and the workers again join there or not join there and they've left, they are entitled to these medical benefits and compensation. This is again the activism part of the Supreme Court coming out. Now, we've had a number of cases where the state governments had to intervene, even the Supreme Court had to intervene, where the cities weren't filled. Garbage was not being picked up, there was dirt all around, water all around, mosquitoes spreading, diseases, malaria, dengue, everything like that. Now, there was one particular case called L.K. Khoolwal versus State of Rajasthan. In this particular, this is again where the courts reiterated the role of not only the citizens under Article 51AG of the Constitution of India, but also of the state and the municipal authorities, the municipal council, to see that garbage is properly removed from the city and cleanliness is done, and they don't want any excuses. Now, this particular case makes me discuss and take you back to a very important decision which was given by Justice Krishna Iyer along with Chinnappa Reddy, Justice Chinnappa Reddy, years ago, and which is a landmark decision even today. It comes under public nuisance. Okay, it is the famous municipality Ratlam case, Ratlam versus Vardichan. It happened in 1980. It was the AIR 1980 case. Now, in this case, students, what had happened was that there's this little town called Ratlam in Madhya Pradesh. They had streets where on one side of streets, there were very poor people living. They used to, just be doing their activities, also their daily chores over there, littering over there, passing excreta, no public toilets, no proper drainage system, mosquitoes were rampant. Okay, there was a brewery also, the water was just being released, the effluents, nobody was bothering about it. And just across the road, there were very huge, sprawling houses where very rich people and affluent people lived. Now, nobody bothered about the poor people here. It was only the rich people, when they were affected, that they went with a petition under Section 133 of CRPC before the magistrate and asked him to remove the nuisance, that is the public nuisance, under Section 133. The magistrate concerned wrote to the municipal authority of the place and said to construct a drainage system and provide toilets for the poor and to see that the sewage was properly managed. But the municipal authority said that it did not have enough resources, financial resources, and could not do it. Finally, from the Sessions Court to the High Court, the matter reached the Supreme Court. And Justice Krishna Iyer gave a beautiful judgment in this case. He said that had the municipal corporation or council in the place of Ratlam taken action at particular moment, or the State Pollution Control Board, or the state government, or the so-called politicians of that place, so many years would not have passed and unnecessary time, energy, and cost would not have incurred. He said, when such an incident or such incidents affects the life of the person, then the may word, which is there under Section 133 of CRPC, has to be construed as shall, and the magistrate must remove the public nuisance. And he said that if it is not done by the pollution control bodies, then they will have to face the music. And in this case, the officers of the municipal authorities would have to go under Section 188 to jail. And he said very clearly that he would give 3 months to 6 months for the establishment of new toilets for the poor people and a proper drainage system. And he said, we do not want 5-star hotel toilets. Nobody is asking you for that. We just want functional toilets for the poor people so that they can go there and not dirty the place. And they can also live a life of dignity, a life with dignity, which was not given to them. And the court said that here, not only, the toilets have to be given, but even the drainage system. So Section 133, students, which was the dead letter law for so long, was ignited by Justice Krishna Iyer, and he put vigor into it and power into it. And to date, it is a very potent weapon for removing public nuisance. Now, coming back to this, what Krishna Iyer has said. Now, when I take other cases with you, there's another very important case by the name of Research Foundation for Science, Technology, Natural Resources Policy versus Union of India, 2005, 10 SCC 510. In this case, students, the Supreme Court discussed the various provisions of the Basel Convention and the Hazardous Waste Rules 1989 and said that when the people, the business people in India are importing hazardous waste or waste like furnace oil into our country under the garb of recycling, we will not allow it unless we are promised that they would be properly disposed of. They said that we want proper guidelines for this, otherwise import will be stopped. So again, students, we also had many cases relating to the vehicular pollution being caused by the motor vehicles in Delhi, in the NCR region. We also had the CNG case where the entire diesel run buses, the whole fleet had to change to the natural gas. They said that because it is causing a lot of pollution. I'll give you the citations. It is MC Mehta versus Union of India, 2001, 3 SEC 756. Then we have again MC Mehta versus Union of India, 2002 4 SCC 356. Now, I'll take two more cases because there are many cases. I can't finish them in just 1.5 hours or 2 hours. There's a very important case which was decided in 2018 by the Supreme Court. It's called Arjun Gopal versus Union of India, 2018 SCC. It's an online SCC 2018, given on 28th October. This was where pollution was caused by firecrackers. Okay, this is not the first case of a kind on firecrackers. Earlier also, there were 2-3 cases where the court had said that after 10 o'clock, no firecrackers would be burst in Delhi. After 10, you have to put a stop to that. And I remember then I was at Jamia, and many students are very cautious about it, school children also. But still, things did not really stop, and it was happening. And after some years, public forgot about it. And you do understand that public memory is very short everywhere. So here the matter was taken up by the judges again, and they said that only green crackers would be allowed. But what was the shortcoming of this case was that the court had said that only green crackers should be burnt, and crackers like firecrackers, anar as we call, flower pots, and rockets, all should be banned completely, manufacture and also bursting of such crackers. The court did not lay down what it actually meant green, what to use for making green crackers. So that was something which created a lot of confusion with the public, and it was right around Diwali time. And this has to be sorted out. Now, another case which came, students, again this year, it was MC Mehta versus Union of India, 13 January 2020. In this case, environment pollution was not only related to air pollution, but even water pollution, vehicular pollution, and a slew of guidelines, measures have been laid down by the Supreme Court of India. Okay? And the Supreme Court has said that smoke towers should be set up in different parts of Delhi, NCR, maybe one in Connaught Place or one in Anand Vihar and other places. Of course, we had the lockdown then. Then an anti-smog guns should be used in Delhi and NCR region, for large construction sites, road construction stretches, mining activities, large parking sites, large gatherings, demolition sites, sprinkling of water in congested corridors where traffic is going. And then also wherever industrial pollution is being caused, whether it's Haryana, whether it's UP, whether it's Punjab, or whether it's NCT, and also pollution caused by industries within and outside Delhi. Now, gradually, the Supreme Court has also been talking about vehicular pollution and also been upgrading the vehicles from, Euro 2 to 4 to 6, and also giving a little relief to the producers now and then and to the private vehicles who are driving, and also saying that after a certain period, diesel cars would not be allowed at all, and allied things. Now the situation is that till these measures were being passed, directed by the Supreme Court has also a committee, to deal with environmental matters and give it data to know what the authorities have done, the authorities in Delhi, Haryana, Punjab, Rajasthan, whether they've really worked on it or not. And they want, the status report to be submitted before it within, say, 4 weeks to 6 weeks. But then the lockdown happened. Okay? So the lockdown has shown that the pollution levels have come down now. Okay? We do see it because the cars are not there. Of course, the Delhi CM had earlier, resorted to odd and even days, but it did not really make any difference. So there has to be another decision, very drastic measures to be taken. Of course, at the moment, when you talk about coronavirus, COVID-19, this is also a pandemic, and it is the duty of the state, duty of the government of India, duty of the government of every state governments to see that it is contained. It's causing pollution, and we have a right to life and personal liberty under Article 21 of the Constitution. And we cannot hear from them that there are lack of resources to deal with patients who are dying due to COVID-19. They have to see that the measures are in place. They have to repose the confidence in the public in every state of the country, not only in Delhi, in every state. 5 states are more affected, and it is the duty of the government under the environmental protection law that they have to play a proactive role, have to play an affirmative role. If Ratlam created a dead letter word and added a lot of vibrance and vigor into it, they have to do it in other laws which are there and which are being applied these days. They cannot say that the population is too large or the population is not listening to us. We have to see that the population listens. We have to see that the poor people are taking on. Everything has to be organized systematically. The rich or the poor, everybody has to get medical attention. It is right to life. Right to life includes within its encompass right to live in a pollution healthy environment, right to a free pollution-free air, pollution-free water, pollution-free air. Again, I reiterate, I repeat, it has to be epidemic-free air that we need to breathe. Yes, our economy has been affected, but we have to strike a balance and we have to take affirmative action to help all of us. Thank you so much. There are still many cases I can take up, but I think I'll take your questions now.
Thank you so much, ma'am, for this part of the session. We've gotten a really great feedback. Everyone's asking for recordings. Everyone wants to know the names of the cases. We'll be sure to do that. We have questions on a couple of things that you mentioned, specifically on how will the role of PILs and environment law change post the coronavirus lockdown. So as we've seen, especially as someone who lives in Delhi, the southern part of Delhi, I am able to breathe easier and breathe freer since the lockdown has started. The air has become much better. So how do you see environment law going ahead after the lockdown and once industry come back on track and all economic activities resumed?
I feel it's a very sensitive issue and the government must do something to take care, because if all the people start coming out, firstly, I fear that there's going to be a wild spread of the disease. We are seeing the numbers going up in Delhi. We are seeing what is happening in Mumbai. Gujarat is also not very good. So when the industries actually start working, a whole lot of migrant workers have gone back at the moment. Unless we come back also, we will not be able to come back on track very easily in the coming few months. And with all the cars coming on the road, I think all of us now should come with a different introspection about ourselves. Like, what do we want? And if we have to improve the pollution and not go back to what we had in the months of October, November, December, smog, I think we should have a very good public transport system and very stringent rules to apply. Only then things will work, otherwise they won't. Because the COVID-19 pandemic is looming large over all of us. And every day we are seeing cases going up. The government has to step in. It cannot pass on the buck to us. We have to look up to the government.
Definitely. Ma'am, another question that has come that's sort of related to, as you said, a lot of times the Supreme Court and the courts in this country give brilliant judgments. However, the implementation of those judgments is impossible. In 2018, the Supreme Court gave a final deadline for banning B4 vehicles in India. That's still not been done as of now, as of 2020. So how do you think the process can be streamlined? Because we've seen a lot of judgments that are great pieces of jurisprudence, especially in environment law, great piece of precedents, but they're just not implemented and they're not translated into real action and real results. So how can we combat that?
There's been a direction given by the Supreme Court lately. It says that it will allow 10% of the unsold B4 vehicles for 10 days to be sold after lockdown in regions except Delhi NCR. This is the latest direction that it has passed. Okay?
Yes, ma'am.
Yeah.
Then we've gotten there's people are trying to see the scope that how can COVID-19 as a subject matter be dealt under the Environment Protection Act. Is there scope for that, or does that only restrict itself to the Epidemics Act? Because seeing that the Epidemics Act goes quite far back into the 19th century.
No, I think it can come. Why? Environment Act is huge. It's got a wide coverage. Okay, and Section 3 of the Environment Act talks about or gives power to the central government to take any measures it can for the improvement of environment. Any measures. It's a sweeping power given to the central government. Okay, so under this, it can do anything to contain the virus. Any measures it can take. I think it should really act now, because we are all worried. We can't move out. We can't work. I'm a citizen. I'm a senior citizen. I can't go and work now. Okay, I'm over 60. I'm supposed to be sitting at home. Okay, and I'm dying to go and work. So how do they take care of people like us? I've got a job.
Right.
You understand?
Yeah,
and even the younger people, there is no assurance that they will not fall ill or they will not fall seriously ill.
Definitely.
The particular virus is going to react differently on different bodies.
Definitely. Ma'am, I think a question that's been at the center of debate in environment law, at least, how can the judiciary balance between protecting the environment and protecting civil liberties? So something like the odd even rule, how it was challenged on the basis of how it's curtailing civil liberties under Part 3 of the Constitution. So how can the judiciary be a balancing act in the sense that yes, you protect the environment, but however, civil liberties cannot be curbed? How can that balance be struck?
When there are reasonable restrictions, those are allowed. Okay, even under Article 19 of the Constitution, if you read. That is why, interstate movement was stopped during COVID-19. Now it's gradually being opened, and it's open. But I feel that because it's being opened, the cases have risen in Haryana, even in Delhi, Noida, and each state is blaming the other.
Right.
But reasonable restrictions have to be put in place where it's a question of life also. Because you understand, the government has to take care of right to life. Right to life includes right to a wholesome environment. Wholesome environment means only if you have a wholesome environment can you have a life of dignity and also right to develop. So the catch is sustainable development. So ecology and development have to go together, hand in hand now. So I think they have to also, I feel, take a feedback from the public and from decision-making bodies and people like NGOs who are working on environment protection. Because they can...
more direct feedback.
I beg your pardon?
A more direct feedback from the people is
Yes, of course. A direct feedback so that, you can include those measures. Because after all, even at the rural level, for example, the panchayati decision becomes very pertinent.
Right.
The panchayats can tell you how to go about in a rural area, how to contain a particular disease in that particular area. So you have to take their help also, everybody's help.
Right. Ma'am, another question that's coming up is that even while giving out reasonable restrictions, certain sectors of the society are badly hit. So in this COVID-19, when interstate travel was banned and a lot of stuff, migrant workers who were sort of the lower economic group in our society were the worst hit. So even in terms of environment law, let's say banning of crackers, a lot of low income groups work in cracker factories. Let's be quite pragmatic about it. So how can we safeguard them as well as the environment? That's become a problem, even though the restrictions are extremely reasonable, but they're still having an adverse effect on the lowest members of society.
Like I told you, that if the Supreme Court has said that we should have green crackers, I think somebody would have to tell us. I'm not a scientist or science expert, but some kind of a product which would not cause too much of pollution, and you can make crackers with that. Like we have herbal, colors when you play Holi. Yeah,
herbal gulal.
Yeah, herbal gulal. So something like that which will not cause problem to the people or cause pollution. It will adversely affect the public. we'll have to think about that.
Then we're getting a few more questions. Yeah, I think. Oh, another question that sort of a question on the entire point. It says how environment policy is a lot of times an executive act by the government, and how can the judiciary challenge that as it breaks the separation of power cycle to an extent? That's a question we've been getting.
Usually, the courts would not want to interfere in the policy decisions taken by the government, okay? Because we have an implied separation of powers doctrine which we are following. But in environmental matters, where the courts have seen that larger section of public is getting affected, even if the courts didn't want it, the courts have stepped in. But this delegation of functions is protected under Article 200 and I'll just tell you, 258 of the Constitution, 258.2 and 258.3 of the Constitution of India. If I'm not mistaken, I'll just quickly check. I've written this here. 258.2, subclause 2 and 258, subclause 3 of the Constitution of India, where there is delegation of the function to the executive under the Environment Act also, but where the executive is not acting, then the Supreme Court on its own will come forward, because it's again the custodian of our rights, and where fundamental rights are being violated. And we can look at the preamble, we can also look at the basic doctrine, and we can all the principles that are laid down with the Constitution of India, because right to life, right to a wholesome environment, right to equality, right to freedom and speech of expression, all these are sacrosanct rights. And if they are going to be affected, the Supreme Court has to step in, because it's the constitutional court and it will interpret the Constitution in favor of the people, because finally the Constitution was made for the people, by the people, and for use by the people. And the power under the Constitution of India is vested with the people of India. And it's not with the representatives. The representatives were only elected, and they were elected by the people. But the power, according to Keshavananda Bharati's case, if you look at the judgment, it is with the people, we the people of India. It is with us. So that comes, I think that takes a primary prominence over executive policies, the policies made by the executive.
We the people of India, I think that's a statement that will be with us for quite a long time. That's the start of the preamble as well. So a question that we're getting is how can we stop judicial activism from becoming judicial overreach? At times there have been criticisms to a lot of judgments, especially recently by the Supreme Court, that they at times overreach their bounds and their jurisdiction. How can we see a balance there as well?
Overreach, yes. There are a few cases where the courts have not taken up under public interest litigation, where there have been private interests of the people involved. Okay, they said it won't come under PIL, but I feel that it depends on the judges also, and the different kind of judges. Like there were judges who were very active in environmental law matters. Okay, if you go back to Bhagwati days and Krishna Iyer days, and also Kuldeep Singh's time, and of course now recently we have other judges also, Gogoi's judgment measures, all these now presently also. But overreach should be avoided. I'm talking in terms of environmental matters only. I'm not talking about other matters.
Yeah, we definitely understand that.
Yeah.
Important to clarify.
Yeah, it's only relating to environment. Now, environment is something which all of us are living in, and where we see that it is being harsh on the people, I don't think it is wrong for the Supreme Court to step in, because executives' inaction has been seen very often. Okay, municipal corporations don't work, pollution control boards don't work, government doesn't work. Government is not implementing the decisions of the court. Look at the Ganga today, it's become dirty again. Look at the Yamuna, it's filthy. There is a plan for the Yamuna cleaning also, but it is taking time. So we see that, and also if you go for places like you go to Bombay, you go to Goa, you see the beaches. Look at the way people are dirtying the beaches. If you look into ecotourism, I mean, there's no other option, but then the Supreme Court has to intervene. And I say somewhere, the citizens also are responsible. Where are they accountable? Where is the civic sense of our people? Okay, they might do it in their houses, but very often we see people throw on lanes, people throw here, and they don't bother, isn't it? So, also, if you take Delhi, how is the waste being burnt? How is the garbage being collected? How is the municipal solid waste being taken? Okay, so that is why the Supreme Court has said, even the policy decision is okay, this part is going to be done by this body. A state pollution is going to do this work. Municipal corporation is going to do that work. But is the work being implemented properly? That is why the Supreme Court has asked for reports. And if it is going to be unhappy, then it's going to step in. It is going to step in. Because it's a question of our life. Right to life and personal liberty. We have to live. We can't die. Like Supreme Court had said in the past few months before lockdown, what do you want us to do? You want all of us to die? The Supreme Court has said, should all of us die? I mean, don't you feel accountable for us? Why are you burning the crops? Why is Haryana government allowing it to come to Delhi? Why is it coming from Punjab? You understand? So,
yeah, definitely.
Coordination is required nationwide, within every state. We do have a federal structure, but then we are not completely federal also. Okay, we have a coordinated federalism in our country, but we need to help each other. Where funds are required, the center should give. Where funds are there with the state government, the state should dispense with the funds. Use them. Use the intelligence of the panchayat system when large projects are going to be sanctioned by the government, be it the state government or by the central government. My God, they have to be sanctioned under the Environment Impact Assessment. We know how often they are not done properly. How is public hearing being given? Just 4-5 people will come and they will say on paper, public hearing has happened. My God, that's not true. Public hearing means a large number of people should take part and give their views. So people, yes.
I think just building on how the ownership needs to go back to the people and how we ourselves are careful. If it's, let's say, I think there's a genuine attitude, and I've seen that from personal experience as well. Once you're outside your house, it's not your country. It's okay, I can litter around. That's been a general attitude. And even secondly, I think just lack of participation in public meetings. So how can we maybe, because public meetings and public discourse is such an integral part of our democracy, how can we strengthen that? And B, should there, I think this has been a debate that's gone on for quite a long time, that should there be stricter punishment for something like littering? Even though it's a very basic question, but it's worked for a lot of other Asian and Western countries.
In our country, environmental crimes are not given importance at all. There's hardly been anyone who's been probably penalized or put in jail for committing environmental crime. Now when we are seeing that during lockdown people are violating the rules, then of course action is being taken against certain people. Okay? But in environmental matters, everybody's quiet. They don't consider it a serious crime like any other crimes. And we also, it's basically we can also call it a socio-economic crime. Okay, where large sections of people are being affected. Look at the way the vegetables are being sold. We do not know if they are adulterated or not. So many, for example, Coca-Cola, it was not selling the product for a very long time. It was discovered that there was a large amount of pesticide in the Coca-Cola that we were consuming. Now this is a crime. It's affecting our health. Why is cancer gone up? It is through food. We are not sure what we eat is unadulterated. So it is the seriousness of the problem that has to be embedded in everybody. not only the government, but even the people. And there should be more and more awareness created, more and more education regarding environmental issues, and not only in schools, in colleges, at the higher level, even in maybe in households. Or housewives should be studied, rural areas. Everybody should become aware that yes, this is an environmental wrong which is being committed. So unless that importance is given by the government, by the judiciary is giving, but then the implementation is a huge problem in our country. That is why contempt proceedings should happen. People don't bother. Way back when the Taj Trapezium case was decided, years have passed, but Mathura refinery is again doing that again and had to get another order in 2012 of contempt proceedings should be initiated. So you understand, even here in 2013 case now, the MC Mehta went. He said, I'm not talking about environment relating to air pollution only. Everything in the NCR region, everything. We go out. Even now, even in lockdown period, we understand there is a dearth of manpower now. People are not coming in numbers as they were earlier. Gradually it is reopening. But we do see the way garbage is littered here and there, and every day it is not really being cleaned up in all places. Okay, and soon we are going to have the monsoons. Water is going to stagnate. Apart from having the COVID-19 problem, we're going to have dengue problem, we're going to have malaria problem, we're going to have other viral issues coming up. How will we manage? So the confidence in the government, the confidence in the judiciary must be restored. They have to work together. So that is why sometimes the rigid doctrine of separation of powers, which is there in the US Constitution, is not followed in our country. And in a way, it's a way of again going to checks and balances, seeing that the other organ is working properly. It's a healthy way because complacency should be given up. Apathy should be abdicated. We all need to be serious and take positive steps. Affirmative role. Isn't it? That is what is required to be played by the government, and the judiciary is playing. Of course, in environmental matters, I don't think it has really exceeded its jurisdiction. In all the judgments that I see, it is, of course, somewhere it is taking the policy decisions, but if the policy decisions are entwined with a bad environment, obviously it has to, step in.
Certainly. I think on the word of monsoons, I'm hearing a lot of clouds going crazy at my end. I think I'm in the South Delhi region only. There are a lot of clouds around here. So I think the most popular question on our webinar or the registration link that we sent out was that how can a student, and most of the people who've joined in are law students, how can a law student pursue environment law as a practice? I think that's a great and encouraging sign, first off. And I'm really glad that we got that question. And I thought I'll put this to you towards the end of the webinar. And I don't see a better time than this because I think it's extremely important and extremely heartwarming to see that so many people want to do that. So, ma'am, how do you...
See, there are firms which are dealing with environmental matters, and you can become an environmental law expert. You can be in touch with maybe me later on. I can also suggest something to you. And there are many lawyers who are just doing environmental law matters. You can be in connect with them. There's a lot of scope, and I feel that you can play an important role and be exclusively an environmental expert in every way. You can give opinions, you can write articles, you can go into deeper research, not only environment within India, also international environmental law has got tremendous scope. Look at now China. It was a place where COVID-19 took birth. Now we don't know whether it was made in the laboratory, the virus, or it was actually nature that had brought it about. So that's a big question, and it has crossed all boundaries and affected the entire world. So it's part and parcel of environment only, but it has also given us an opportunity to see the other side. Right? Look at how animals are coming out. Look at how cleanliness is taking place. The water has become blue now. The skies are clear now. You may be able to see the stars at night, which probably you were not able to see earlier. So this is an area where students can pursue if they exclusively want to do environmental law. There's plenty of scope with NGOs also. There are specific NGOs also working on environmental law. So you just need to, connect with the right people.
Great. Thank you so much. Ma'am, a lot of people are asking if they can drop you a mail regarding the same. Do you want to share that or no, because we're getting a lot of messages. Yeah, I think we'll just, what we'll do is we can send the questions you have to ma'am separately. We'll do that and we'll try and see if we can get answers to those. Make sense?
Okay.
Then I think that's about it. That's about all the questions we have. Thank you so much, ma'am, for giving us your time. We've already
Thank you.
taken more than an hour and a half of your time, and it's great, lovely weather, and I hope everyone goes and enjoys that. And I'll just ask Ariman or Krisha to extend the vote of thanks, and then we can end the session. Thank you so much, ma'am, for your time.
I'd just like to say a few words. Thank you so much for inviting me. I hope all the participants benefited from my talk. And I would also like to thank you for the platform that you've created. I believe it's doing very well. And I think even Jahnavi's platform, that is Virtual Lawyer, has picked up, and she's happy to coordinate with you. And you people are really doing a good job in the lockdown period, because you're carrying legal education forward and seeing that many of the advocates and the students just don't sleep 24/7. Thank you so much. Thank you.
Thank you.